Hi, my name is Evan Mandery. I'm a professor here at John Jay College of Criminal Justice, and I'm here today with my friend Michael Meltsner, who is a professor, a distinguished professor of law at Northeastern Law School, formerly the dean of Northeastern, and before that a professor at Harvard Law School, and before that a professor at Columbia Law School, where he was one of the founders of clinical legal education, a transformative movement in American legal education. And before that, relevantly for our purposes, he was the first assistant counsel at the NAACP Legal Defense Fund. And he has edited and written a foreword to this book, Race, Rape, and Injustice, by Judge Barrett Forster, which was just published by the University of Tennessee Press. And we're here today to talk a little bit about the book. Thanks for coming here today.
Thanks for having me.
Can you tell everybody a little bit about how you became involved with editing this book and what your interest in the material was? Let me say before you answer, I'm sorry, just the book really represents a very significant movement in the 1960s when a group of law students traveled to the South to try and offer empirical statistical evidence of racism in capital sentencing, and Michael was at the fund during that time. So how did you get involved with this book?
Well, at the Legal Defense Fund, we were in the business of fighting discrimination against African Americans. And one of the most blatant forms of racism during that period was the overwhelming statistical showing that whenever blacks were convicted of a rape in the southern states, which were the only states really that had capital punishment for rape laws, they were sentenced to death and executed. Whereas when whites were convicted of rape, they almost always got a prison sentence, or sometimes a very light prison sentence. And the Legal Defense Fund started to focus on this, and the question was, how do you prove this discrimination? Actually, everybody who knew anything about the subject believed there was that discrimination. But proving it for a federal court was another matter entirely. And there had been some egregious cases of this kind of discrimination. The famous Scottsboro cases in the 1930s. And then in the 1940s in Virginia, 7 black men, including 3 or 4 juveniles, were executed in a 2-day period for a rape that may not have occurred in Martinsville, Virginia. So there was a great history of this. The question was, how do you prove it to the satisfaction of a court? And so what happened was the Legal Defense Fund asked a civil rights student organization to basically solicit students who would be interested in going to the South over the course of the summer of 1965 to investigate the court records of thousands of rape cases and chart what happened in those cases. It was pretty clear that 90% of those who'd been executed were blacks who had been convicted of raping white women. But that wasn't enough for the courts. The courts had to know that the defendants in those cases had not used more violence, had not been more culpable, did not have longer criminal records than those in other cases. It's only after negating those factors that a federal court could conclude that there was discrimination in violation of the Equal Protection Clause of the Constitution. So this organization got 28 law students, 27 men and a woman, and they were brought together in Philadelphia for a week and trained how to make these court records into statistical information. In other words, they filled out a long schedule of facts about each case that was in the sample of cases that had been selected. And then these 28 law students dispersed to 11 southern states, and they spent the summer doing this work. That's the story that Judge Forster tells in this book, and he is, of course, he was one of the students, and later became a judge in California, and he wanted to tell the story because it had never been fully told. Now, I ended up editing this book and writing a foreword because in 2010 the judge died rather suddenly. He'd submitted the manuscript, but it wasn't truly finished.